Pagtiyak ng pag-transfer kay former President Duterte from Manila to Hague ay ginawa ko naman bilang pagtupad ng tungkulin. Isang professional na trabaho na naayon sa batas at walang halong personal na motibo. Ang papel ko na ipatupad ang batas, ang papel ko doon talagang ipatupad ang batas at hindi huhusgahan ang kaso. Sabay nito, nakikiramay na rin ako. I'll take this opportunity to condole with the victims of these alleged crimes at sa kanilang search para sa justice na ngayon nga ay dinidinig ng ICC. Ano man ang paninindigan ng bawat isa sa atin sa usaping ito ay hindi natin pwedeng ipagsawalang bahala na lang ang sakit at pagdurusang dinaranas ng mga pamilyang ito. Ang mga ganitong proseso ay of course hindi madali, ngunit ito ay umiiral upang mabigyan ng pagkakataon ng lahat marinig sa ilalim ng batas. Lahat ng panig, prosekusyon, depensa, at yung mga witnesses. At sa uli, ang pinakamahalaga ay masunod ang due process, manatiling patas ang batas, manatiling patas ang proseso at pagdinig, at hayaang gumana ang mga institusyon ng malaya at walang impluensyang politikal. Yan naman lamang ang pananaw ko sa nangyayari ngayong confirmation of charge.
Tanong ko namin yan, General, dahil kasi hindi pa rin nagpapatawad itong nakakalimot yung mga supporters ni former President. By the way, standby lamang, General, at siguro maya-maya ay babalikan po natin itong iba pang mga paksa at usapin hinggil ho rito. At ito muna, bibigyan daan ko muna mga kabombo at mga Castar Nation. And of course, sa inyo po, General Torre, yung pag-usad ng confirmation of charges hearing. And kunan namin kayo muli ng mga reaksyon maya-maya lamang. Mga kabombo, mga Castar Nation, pakinggan at panoorin po natin ang resumption dyan sa International Criminal Court.
Document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial, and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying for the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, a police intervention in strict accord with the use of force continuum and or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect. It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
Maître, je suis désolée de vous en...
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the learned chambers legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald de la Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 00000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part that I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations, Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind, and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out
Okay mga kabombo at mga ka-Star Nation, ating itutuloy mamaya yung pagkalapa ng mga karagdagang update mula ho dyan sa International Criminal Court. At nasa day 3 ang confirmation of charges hearing at ating tabayanan itong kabuuan ng presentation ni Nicolas Kaufman, ang lead counsel ni former President Rodrigo Roa Duterte. And after that, meron ho tayong recap mga kabombo, mga ka-Star Nation, ng proceedings dyan sa bahagi po ng The Hague, para na rin doon sa ating mga late tuners na kakabukas pa lamang ho ng kanilang Bombo mobile app at yung mga bumabiyahe, mga pauwi sa kanilang mga tahanan na nakatutok ho dito sa ating special coverage mga kabombo. And kanina naudlot din ho yung ating pakikipag-usap dito kay Metropolitan Manila Development Authority General Manager Nicolas Torre III. Mamaya ho, itutuloy natin yung pakikipag-usap po sa kanya hinggil doon sa mga usapin na nakapaloob ho nung kanyang inaresto si former President Rodrigo Duterte. Malapit na ho kasi yung anibersaryo sa 11 ng Marso ay isang taon na dyan ho sa piitan sa International Criminal Court, itong si former President Duterte. So bago ho yan, resume muna tayo ng pagtutok dito sa mga argumento ng lead counsel ng panig ng depensa, si Nicolas Kaufman, mga kabombo.
Prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station was sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law, unwritten proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic, building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, 2 of 3 of whom supposedly formed the hardcore of a more limited organisation referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001 2584 at lines 248 to 250. Okay, that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001 2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather
mga kabombo at mga ka-Star Nation, tuloy-tuloy pa rin ito si Nicholas Kaufman sa pag-counter mula ho dun sa mga testimonya ng panig ng prosekusyon itong nakalipas na araw. At kanyang pinupunterya yung mga argumento. Mapapansin natin na inilarawan pa niya ito na yung diskarte raw ng prosekusyon ay parang may hahalin tulad dun sa cart na mas nauna pa yung cart kaysa dun sa kabayo. Parang ganun daw. Hindi organisado yung pagtingin niya tungkol dun sa mga argumento ng panig ng prosekusyon. At ito ay nilarawan niya dahil ho dun sa ilang mga punto at mga terminolohiya na ginagamit ng panig ng prosekusyon na kung titignan ay dun mismo nagkakaroon ho ng conflict para sa partikular na mga punto na nais ipakahulugan kaugnay doon sa termino na neutralize na ginagamit ng mga opisyal sa panahon ng Duterte administration at pinakakahulugan nanumano bilang pagpatay yung neutralize gayong ito ay direktiba para ho sa mga otoridad upang pigilan ang anumang paggawa ng masama ng mga individual na tinutukoy, partikular na ho yung mga sangkot sa illegal na droga. At ang direktiba mga kabombo ay nasa circular ng pambansang pulisya during that time ni former President Rodrigo Roa Duterte. Pati na yung iba pang mga argumento ay inungkat din itong si Kaufman. Maya-maya mga kabombo ay kukunin natin ang recap ng naturang bahagi ng salaysay o kaya naman ay argumento ng lead counsel ni former President Rodrigo Duterte. Ang iba pang mga bahagi po ng panig ng depensa ay present din, ngunit ang nagsasalita pa lamang itong si Nicholas Kaufman bilang lead counsel ng naturang dating leader ng Pilipinas na ngayon ay nakapiit ho dyan sa International Criminal Court Detention Facility. So ayan mga kabombo, mga ka-Star Nation, at least nabigyan ho ng pagkakataon ng panig naman ng depensa upang ilahad ang kanilang kabuuan ng counter o yung pagtutol at pagsalag dun ho sa mga atake ng panig ho ng prosekusyon, mga kabombo at mga Castar Nation. So yan yung kagandahan, ano, nabibigyan ng sapat na pagkakataon ng magkabilang panig para mahimay ng husto itong mga argumento na kanilang isinusulong dyan sa harap ng mga huwes na hahatol kung ito ho ay uusad ang kaso o kung tuluyan ho itong mababasura at maaalis sa pagkakapiit itong si former President Rodrigo Roa Duterte. So naka-standby pa rin ho si General Nicolas Torre III ang umaresto kay former President Rodrigo Roa Duterte. Halos mag-iisang taon na ang nakakalipas, mga kabombo. So ituloy ko lamang ho, General Torre, yung katanungan na naudlot kanina dahil sa resumption itong confirmation of charges hearing dyan sa panig ho ng International Criminal Court. Kanina natanong ko ho yung tungkol doon sa kung hindi ba kayo nagsisisi, ano? Na kayo yung mismong gumanap ng tungkulin na pag-aresto kay former President Rodrigo Duterte. Alam ko kasi naging subject ho kayo, naging sentro ho kayo ng mga kritisismo ng mga supporters, of course, ni former President Rodrigo Duterte. Kahit nga yung mga opisyal ng International Criminal Court ay hindi rin ho nakaligtas doon sa mga batikos, ano, pati yung mga natatanggap na mga pagpuna kahit sa page 2 nila ay punong-puno ng mga pagpuna galing ho doon sa mga supporters ng former president. And kayo, so far, ano yung inyong masasabi hinggil dito, General Torre?
Natural lamang yun kasi may kanya-kanya tayong opinion. Ang opinion nila ay ganon at kaya talagang nire-respeto natin. We will fight to death para depensahan sila na ang karapatan nila na magsalita ng ganon. Pero hindi ibig sabihin na sang-ayon tayo sa opinion nila. Sapagkat ang posisyon ko naman ay hindi nagbabago at maliwanag na ang pagtrabaho ko na yon ay isang professional at walang halong motibo na personal.
Okay, General Torre, kung sakali ho na ito'y aabot sa full trial at kailanganin ho ang inyong pananaw o kaya naman ay kunang kayo ng testimonya, well, siguro pupunta kaya kayo. Pero bago nyo ho sagutin yan, eto, bigyang dahil ko muna itong pagpapatuloy po ng confirmation of charges hearing. Nasa highlights na ho ito ng mga pahayag ni Nicholas Kaufman. Uy, tukayo nyo ho pala ito, no? Ito, pakinggan ho natin.
P3.
Ayan, mga kabombo, mga Castar Nation, oras natin sa buong kapuluan, 10 minuto bago sumapit ang alas 8 ng gabi at tayo nakatunghay pa rin dito sa mga development dyan sa International Criminal Court, and we're trying to connect again dyan ho sa confirmation of charges hearing sapagkat kumbaga nasa huling bahagi na ho ito, hindi pa man huling-huli, ano, pero nasa higit kalahatian na ho yung hinihimay nitong si Nicholas Kaufman kaugnay ho dun sa mga argumento na kanilang pinupuna dun sa mga aligasyon ng panig ng prosekusyon, no? Ito ho kasi yung trabaho ng lead counsel ay gibain yung mga in-establish ng prosekusyon na mga akusasyon laban sa isang suspect sa krimen na kanilang ipinupursige laban kay former President Rodrigo Duterte, mga kabombo. So, check natin muli yung linya dyan sa International Criminal Court. Atin hong tunghayan at panoorin, mga kabombo.
To show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders which the prosecution has identified occur specifically because of Rodrigo Duterte's involvement. Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006-0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecution's fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.
Mga kabombo, mga ka-Star Nation, naka-break muna ang panel ng mga huwes dyan ho sa International Criminal Court sa mga sandaling ito. At after 90 minutes ay magre-resume uli yung huling bahagi na ng argumento para sa panig ng depensa o yung kampo ni former President Rodrigo Roa Duterte. Samantala mga kabombo, mga ka-Star Nation, ituloy lamang ho natin yung ating naudlot na pakikipanayam dito kay General Nicolas Torre III at mamaya ay bibigyan din ho natin yung mga recap nitong mga pangyayari dyan ho sa tinutugay-gaya natin na kaganapan sa The Hague sa bahagi po ng Netherlands. So nandun na ho tayo sa issue ng kung sakasakali lamang ito'y what if lang naman. Hypothetical question ika nga kung sakali ho general na uusad na yung full trial at kailangan po yung inyong testimonya magiging bahagi po nung investigasyon, kayo ho ba ay willing na pumunta at humarap dun sa mga huwes ng International Criminal Court knowing na kayo mismo ang siyang nanguna sa pag-aresto sa former president, lalo't may aligasyon ho ng kidnapping ang kanyang kampo against the government of the Philippines, General?
Opo, kasi pag tayo tinatawag ng ganyang mga tribunal, nung nangyari ang lahat ng yan, talagang valid ang membership natin at effective pa ang membership natin. Kaya manghihingi lang siguro ako ng authorization sa ating gobyerno na pumunta at mag-fulfill ng duty kung ipapatawag tayo ng ICC. Ngayon, susundin natin siyempre kung ano ang last say ng gobyerno. Pag sinabi ng gobyerno na hindi, hindi. Pero kung sinabi ng gobyerno, okay, dahil kailangan nating irespeto ang ating mga obligasyones sa ICC, then so be it. Pupuntahan natin at i-fulfill natin. Gaya ng pagtupad natin sa iba pang naging trabaho natin sa mga nakalipas na panahon.
Ito naman ho, General, I'm just curious. Sa part ho ng mga co-perpetrators, ang sabi ho po ng mga nakausap namin na mga accredited ng International Criminal Court, yung mga accredited lawyers, may baka raw malapit na rin na ilabas po yung warrant of arrest doon sa 8 na mga co-perpetrators. Bagamat hindi sinasabi na lahat po yun ay agad-agad may isyuhan ng warrant of arrest or sabay-sabay kaya sila. Hindi pa ho malinaw sa ngayon, even yung mga lawyers na accredited ng ICC ay hindi pa rin ho yan masabi. Ilan ho sa mga nasa listahan ay inyong kulig mismo dyan sa Philippine National Police kung saan kayo kabilang dati. Ngayon, pagka nagkaroon ho ng warrant of arrest at simulan ho ng Philippine government yung paghahanap, yung manhunt operation, are you still willing to assist? Hindi man siguro kayo yung mangunguna dahil meron na ho tayong mga nakatalaga na mga tauhan at opisyal ng Philippine National Police for that. But of course, kung halimbawa kailangan ng inyong expertise, hihilingin ng mga nakakataas na opisyal po sa inyo, given na ho yung lawak ng inyong intelligence capacity and everything, yung experience of course ay hindi may aalis. Lalo dati ho kayo na namuno dyan sa Criminal Investigation and Detection Group. Are you still willing to participate or to help, General?
Depende na po sa order na ibibigay ng gobyerno sa akin. Pero I don't see any reason na bakit pa ako matask sa pag-implement ng mga kung may lalabas mga warrant. Kasi hindi naman ako pulis at ako'y nandito na sa MMDA. Wala naman sa mandato ng MMDA ang mag-implement ng mga warrant of arrest, whether it's on local courts or international man. So I don't think that I'll be summoned on that matter.
Ayun, Okay, ito na lamang ho, General. As of now, may nagtatanong na po sa inyo about, posible na pagtulong po ninyo sa manhunt kung sakasakali. Siguro yung, kumbaga, guidance na lamang, kung sakasakali, pwede ba kayong maging advisor ho nila sapagkat iba yung diskarte ng General Torre. Nasubukan ho ito sa ilang mga pagkakataon. So at least the guidance for them from your end, General?
Wala pa naman po. At kung may magtanong man, yan din ang isasagot ko. Hindi naman ako na pulis. So I don't think na ako pa ay atasan. There are 220,000 hardworking policemen all over the country, and I think each and every one of them is capable of implementing that warrant.
Ito tanungin ko na rin ho kayo at medyo samantalin ko na ho yung pagkakataon na nasa linya kayo ng ating komunikasyon. Medyo light moments ika nga. May mga usap-usapan na ho na kinukonsidera kayo ng Marcos administration at ng iba pang mga political parties na, para sa susunod ho, na halalan sa 2028. Pero matanong ko lang, may kumausap na ho ba sa inyo from any political party so far?
Ayun na ho, hintayin ang 2028. Tatakbo po ako sa this coming April. Takbo laban sa mga bully part 2. Na natin ginawa ang part 1 yan last November 16. Kaya ngayon, andyan na. Abangan nyo at kayo inimbitahan ko sa ating takbo laban sa mga bully part 2 yan sa ating habang tayo na sa MMUE.
Yun, siguro, ako rin, parang gusto kong tumakbo tuloy, pero takbo para ho sa good health, ika nga. Okay, so with that, maraming salamat po, General, sa pagsagot sa aming mga katanungan sa pagkakataong ito. And ingat ho kayo. Good luck ho sa inyong mga ginagampanan dyan sa Metropolitan Manila Development Authority. Maraming salamat.
Yes, sir. Maraming salamat po sa inyong suporta.
Mga kabombo, mga Castor Nation, nakausap po natin ang kasalukuyang General Manager ng Metropolitan Manila Development Authority, General Nicolas Torre III, dati hong pinuno ng pambansang pulisya. At kaya ho natin siya nakausap sa pagkakataong ito sapagkat mag-iisang taon na nga ho mula nang maaresto ng kanyang team, si former President Rodrigo Duterte, na ngayon ay nakasalang ho sa confirmation of charges hearing dyan ho sa The Hague sa bahagi ng Netherlands. So mga kabombo, mga Castor Nation, standby ang atin po mga himpilan. Mamaya ay muli ho tayong tututok dito sa mga development dyan sa The Hague at tayo ho ay antabay pa sa mga kaganapan sa International Criminal Court, mga kabombo at mga Castor Nation. Tutok lamang at mamaya resume tayo, mga kabombo, mga Castor Nation. Unload lamang ho tayo ng mga commercials para sa ating mga himpilan sa mga himpilan ng Bombo Radio Philippines at Star FM. Mga kabombo, mga Castor Nation, antabay lang, standby.
Mga kaayuhan nga magkuha sa motorista nga magsulob sa helmet. Una, kahatagan sa proteksyon ang ulo ug utok sa tao. Kini tungod kay ang maong bahin sa lawas ang labing sensitibo sa damyos nga kun dili ka panalipdan, hayan ikamatay sa tao. Dakog tsansa sa survivability. Ang tao nga nagmaneho sa motorsiklo ug bisan ang iyang angkas kung kanunay batasanon ang pagsulob sa helmet sa matag biyahe itandi sa mga taong